big breaking news coming in. The court is currently dictating the order, so any minute now we're going to expect that big word coming in from the top court, and Justice Banerjee has said that status quo will be maintained. We were just holding a discussion on the status quo aspect of it and how Kapil Sibal and Dushyant Dave went on to say that status quo must be maintained if nobody has had to organize any such event on this land for 200 years. Why this kind of an intervention now? And with regards to the order, Justice Banerjee has said status quo will be maintained. The Supreme Court has ordered status quo as of today will be maintained, is what the top court is saying. Especially if petition has been disposed of, so certainly in that sense a setback coming in for the Karnataka government, and a big victory in that sense for the Waqf board, because the Waqf board since the very beginning, be it the two-judge bench and now in front of the three-judge bench, has been citing the 1964 Supreme Court judgment, has been saying that the land is rightfully theirs, they have the sole claim on the land, they will do what they feel with that very land piece. Now let me go across to Nilashish, who's joining us with more details. This is big breaking news coming in, a setback for the Karnataka government, Nilashish, and victory for the Waqf board. All right, before that, Harish is joining us on the phone line, our legal editor who's been getting us all those details from the top court. Harish, over to you.
Yes, so that's right. It's a huge setback for the Karnataka government and the municipal corporation, as the Supreme Court has set aside the judgment of the ruling of the two-judge bench of the Karnataka High Court, which had in fact permitted the Karnataka government and the municipal corporation to hold the Ganesh Chaturthi celebrations in the Bengaluru Eidgah Maidan. But today, the Supreme Court order has said that the status quo has to be maintained, and in fact, the Supreme Court bench led by Justices Indira Banerjee found merit in the argument of Kapil Sibal, who had appeared for Waqf board, that the balance of convenience was in their favor, because for the past 200 years, no such celebration had been done, was not permitted, and prima facie, even in the revenue records showed that this land was a Eidgah land, and continuous revenue records proved that the land belonged to the Waqf, and therefore no such celebration could not be permitted by upholding the rights of the minorities communities to administer their property. So, remember during the hearing, the Waqf board had also cited the Places of Worship Act, which said that status quo has been maintained as of 15th August 1947. So it's a huge setback for Karnataka government and municipal corporation, as Supreme Court has disallowed them to hold the Ganesh Chaturthi celebration in the Idgah Maidan.
And with regards to the last leg of the hearing, Harish, already look like things are going to be turning in the favor of the Waqf board. But as far as this order goes, what about the longevity of this order? For how long does this order stand valid? Are we just talking about the next 2 to 3 days that were the bone of contention here with regards to the Ganesh Chaturthi celebrations?
Yes, that the entire prayer was for allowing the Ganesh Chaturthi celebrations scheduled for tomorrow and day after. The Solicitor General Tushar Mehta, who had appeared for the Karnataka government, vehemently pleaded that at least, even Mukul Rohtgi said that the one should be broad-minded and look at the celebrations. Otherwise, the Solicitor General said that at least for 2 days, allow the celebrations, and day after tomorrow, the ground will become as back to normal, and all these temporary structure will be dismantled, and the status quo will be maintained. But Supreme Court said that as of now, prima facie, the Supreme Court felt that the balance of convenience is in the favor of the Waqf board, as for the last 200 years, no such celebration was allowed, and they had prima facie evidence that the land belonged to the Waqf board, and in fact, so no such relief could be given.
Okay. And what about the options before the other side? What else can they do now? Well, we're just a few hours away from when the celebrations are to kick in across the state, but do they have any other legal options left with them?
No, since this matter has been, the order has been pronounced by the Supreme Court, as of now, there is no legal option for them because the celebration is tomorrow. Remember, even the matter had gone to a two-judge bench of Justice Hemant Gupta and another judge, and then from there it had gone to the three-judge bench. So even today, the matter had been heard extensively by, it was a marathon hearing from 2:45 till now. Two benches have heard the matter, and finally the outcome is that the Karnataka government and Bangalore Municipal Corporation has been asked to maintain the status quo.
All right, Harish, one last question. Now, we had Justice Banerjee and Justice Oka, both of whom opining that for 200 long years, none of this was done. So why make any sort of changes? Why not let status quo be maintained? What was the turning point during the course of the arguments that were being presented by both the sides? Harish, can you hear me?
Yes, please repeat your question.
Yes, I was meaning to ask you as to, since you were witness to the arguments that were being presented by all sides, what was the turning point really? Because both Justice Banerjee and Justice Oka were of the opinion that status quo be maintained. None of this was brought in for 200 long years, so why now? What was the turning point really?
Yes, in fact, the turning point being that the Supreme Court, the senior advocate Kapil Sibal and Dushyant Dave Dushyant Dave, in fact, pointed to the 1964 judgment of the Supreme Court, whereby prima facie it was observed by the Supreme Court that just because a place is an open playground, it does not mean that the property belongs to the state, and lengthy and continuous revenue records proved that this land, in fact, was an Eidgah, and there was a Supreme Court judgment also had in one of its parts said that there was a Qabristan in it. So, and even the Waqf Board said that even the last 200 years, no such celebration had been allowed, and they also pointed to the Places of Worship Act, which in fact protected the character of a religious place, and said that status quo should be maintained as on 15th August 1947. So all these arguments were put forward. They had also vehemently argued that the single judge in fact had given an order in their favor, and also allowed modification of the order, but despite the single judge saying that there can be modification of the order, they had straight away gone to the double bench and got an order in their favor. And in fact, they also argued that this Maidan, this Eidgah Maidan, in fact, the religious structure of the Eidgah Maidan should be preserved, because this is part of the protecting the property of a minority community, and no message should go that rights of minority community were being trampled upon. So all these arguments were taken into consideration, and Supreme Court bench led by Justice Indira Banerjee repeatedly asked whether we have only one question: has such a celebration like Ganesh Chaturthi celebration been carried out in the Eidgah Maidan? But always the answer was no. And the Supreme Court also pointed out to the fact that there were several injunctions against the Bangalore Municipal Corporation, but Mukul Rohtgi, appearing for the Karnataka state government, said that the injunction was for building a school in the ground, not for getting for a passage, or not going into the Maidan. But Mukul Rohtgi also argued that the party before the Supreme Court is not the municipal corporation but the state, and whatever injunction was there was the injunction order was being passed against the municipal corporation and not the state.
All right, Harish, now what about the division bench judgment? Because, you know, it did come across as, at least until a few hours ago, that all was in place for the government to just give a go-ahead with Ganesh Chaturthi celebrations at the Idgah Maidan, and that was, of course, in modification to what the single judge bench had ruled. So what happens next?
Yes, now in fact, remember the Karnataka government and the corporation had suffered a setback from the single judge or single bench of the Karnataka High Court, but then they had rushed to the division bench, which had given them relief, saying that they can issue orders regarding the celebration of the Ganesh Chaturthi at the Idgah Maidan, but against which the Waqf board had come to the Supreme Court. From here, the Supreme Court had in fact restored the single judge order of status quo at the Idgah Maidan. So as of now, since the order has been passed by the Supreme Court, that order will prevail, and the order of the division bench of the Karnataka High Court, which had allowed the Bengaluru Municipal Corporation and the Karnataka state to hold the Ganesh Chaturthi celebrations at the Eidgah Maidan, will stand scrapped, and what is the meaning of the Supreme Court order is that the Bengaluru Municipal Corporation or the Karnataka state government cannot host any Ganesh Chaturthi functions tomorrow or day after. And remember, tomorrow is the day of the Ganesh Chaturthi festival, and there is no time left for the Karnataka state or Bengaluru Municipal Corporation to even file an appeal.
That's the final word coming in from the top court, and a big relief for the Waqf board in that sense. No Ganesh Chaturthi celebrations with regards to the Eidgah Maidan, as was being contended by the Waqf board. Thank you, Harish, for joining us and giving us all those non-stop updates from the top court.